For the benefit of a couple of you here that weren't here this morning, I introduced to my right on the panel Judge Tim Easter from Williamson County. To my left, Judge Tom Greenholz from Hamilton County. I'm Kirkwood Witt, and I'm from Monroe County. And we have the one case on the docket this afternoon. Call the case, please.
State of Tennessee versus John Shaffighi.
Thank you.
Here for the appellant.
Mr. Rice, what?
I'm saying I'm here for the appellant, Your Honor. Here for the appellant, Mr. Shaffighi.
Yes. I didn't quite understand your first remark. Come on to the podium and be ready to go, Mr. Isaacs. We're happy to have you. I understand you're taking a little break away from Knox County to get down here today to argue the case. Is that right?
May it please the court, I shared with my colleague a case that this court returned to Judge Green at State versus Micah Johnson. So he was kind enough or cruel enough to stop jury selection and allow me to come over and argue the case.
We're happy to have you here, and I'll refresh your memory. Arguments are 20 minutes aside. If you want to reserve a portion of that, let me know now if you want to reserve time for rebuttal.
May it please the court, I would like to reserve 5 minutes for rebuttal.
All right. Very well, thank you. Go right ahead.
May it please the court, this case began in October of 1991. 10-year-old Miss McLaughlin enrolled in the Shaffighi karate studio. It was a thriving, successful enterprise wherein Mr. Shaffighi tutored approximately 300 students. At some point, based on the relationship between Mr. Shaffighi and the 11-year-old, there was an agreement to provide some private lessons. The lessons were provided at the Shaffighi karate studio, which was a very open, modern studio with a lot of windows, not a lot of doors or enclosures as reflected in the record. During that process, from October of 91 until August of 92, the child made no complaints about Mr. Shaffighi's conduct or behavior. At some point, based on the fact that the karate studio changed locations and the price increased, her family decided not to enroll her for the next session. So she terminated her attendance of the karate studio in August of 1992. Subsequently, 4 months later, and for the first time, she made an allegation that she had been touched, although it's somewhat nebulous, to a friend named Elaine. Those allegations changed and morphed. Elaine told her mother. Then there was a referral to the Department of Children's Services. At this point, the record is unremarkable, but for a 30-minute recording with a recording by Miss Mathis Judd of DCS. The child was asked a number of questions, leading questions. The interview was not video recorded, and that recording became the centerpiece of the prosecution of Mr. Shaffighi. The record reflects that law enforcement, the Knoxville Police Department, in addition to the Department of Children's Services, did virtually nothing in this case. There were no search warrants. There was no photographs taken of the karate studio. There was no swabs. There was no DNA. There was no attempt from DCS to interview Elaine, the friend to whom the initial disclosure had been made. So simply put, the case began and ended around that recording. Mr. Shaffighi was contacted. He had gone to Iran, voluntarily returned to the country, and agreed to be interviewed, signed a rights waiver, and on February 8th, Mr. Shaffighi asserts that he was polygraphed and gave a exculpating statement to law enforcement.
Mr. Isaac said the trial court in the case found that the polygraph did not take place. Is that correct?
That was finding there was a dispute. There was an affidavit from Mr. Shaffighi and an affidavit from the law enforcement officer. We were unable to have an evidentiary hearing because of his health, but yes, that was the finding.
So on the Ferguson issue, does the Ferguson issue end at that point then, where the trial court says that the evidence that you all claim was either negligently or recklessly destroyed by the state, that the evidence didn't exist in the first place? So is that where the Ferguson issue
Well, it's a two-pronged Ferguson-Merriman motion. Mr. Shaffighi was interviewed. There was the dispute about the polygraph, and there was also a statement taken based on Mr. Shaffighi's understanding of the English language. There was a transcript which was significantly unintelligible, but the audio recording was lost. So Judge Greenholz, in addition to the polygraph information, the audio recording of Mr. Shaffighi was inexplicably lost, even though a transcript was still maintained by law enforcement.
Now, this transcript or this recording was made back at near the time of the allegation surfacing. Is that correct?
That is correct. And it was important to the defense because what it showed was Mr. Shaffighi returned to the United States, was Mirandized, gave a statement without a lawyer that was exculpating. And ironically, they had saved the audio recording of the 11-year-old, Miss McLaughlin, and had inexplicably lost the recording of Mr. Shaffighi, where he adamantly denied all of her allegations contemporaneously when they were made. So you have one recording that was inculpating, that was preserved, the other recording of Mr. Shaffighi lost. And it is our position on the first issue, aside from the finding on the polygraph, that under Ferguson and Merriman, this was constitutionally material. It was potentially.
How is it material? So is the defendant's own statement, how is it admissible at trial by the defendant?
Well, it would have been, we would have been able to, if we had decided from a strategic standpoint to put Mr. Shaffighi on the stand, to conduct investigation, to juxtapose her statement with his statement that was exculpating.
If he testified at trial, the statement only could come in as a prior consistent statement after his credibility had been attacked. Is that correct?
Correct. Just as the state did in the statement of Ms. McLaughlin. Absolutely.
Okay. Did the defendant testify?
He did not. Because we were left with a transcript, and I believe because of the Ferguson and the Merriman issue, the state chose not to use the transcript against him. So
how is it material?
It's material because it would have, at the time, shown that he voluntarily came to this country, returned, and expressed his innocence. And it could have been played in opposition to the statement of Ms. McLaughlin, which was...
Those facts not otherwise admissible, that he returned voluntarily to the country? Did those come in through another witness, for example?
It would have been more pronounced. Again, the officer that was involved, unfortunately, was extremely ill and in hospice at the time this matter was tried. But yes, we would have been able to show, here is a recorded statement of Ms. McLaughlin, here is a statement of Mr. Shaffighi, who traveled halfway around the world to assert his innocence. So absolutely, it was constitutional.
Did the jury not know that?
No.
Okay.
And we raised this issue in front of Judge McGee. We raised it again in front of Judge Green. Pre-trial, we raised it at trial, and it clearly, in our position, obviously there is. Now, with the polygraph, I will concede that the record is not clear on whether there was lost evidence or destroyed evidence based on the conflict. But with this audio and the transcript, absolutely, we've reached that threshold. This case was unique in terms of the state with absolutely no investigation, no corroboration of the child's statement. This recording of Miss McLaughlin and Miss McLaughlin being able to listen to it time again prior to her testifying became a preeminent factor in our defense of the case.
I'm sorry to interrupt again. I know we have a limited time here. Could I talk a little bit about the issue that you raised with respect to the victim testifying? You'll have to ask him. I think you raised that as an issue infringing upon the defendant's right to remain silent.
Yes, Your Honor. Judge Greenholz, we raised the issue of the court failing to grant our motion for mistrial. In that instance, we cite the court to the Jackson case where a prosecutor said to the defendant, "Tell us where you were." In my cross-examination on 2 occasions, she indicated that one question, in response to a question on the lack of witnesses, because it was uncanny, 300 people, but no one ever saw anything inappropriate, or there was no ability from DCS to figure out when the studio was open, when it was closed, to even corroborate that these allegations, which were bizarre, that she was standing on a cement block blindfolded for 25 times, not a single date, time, etc., was offered or confirmed in the investigation. But when that issue came up on cross-examination in response to a question regarding lack of witnesses, she said, "You will have to ask Mr. Shaffighi that, because I know I was there by myself. Why did no one saw you leave or arrive at the studio? Who would have seen you? John Shaffighi." It happened on 2 occasions, clearly violated my client's Fifth Amendment right. And under Jackson, when you juxtapose the statement that was made regarding "tell us where you were," we assert that that is clear error that was contained in the record.
But Jackson, that statement was made by the prosecutor, correct? And not
That's
the
correct,
witness.
Judge Easter. It was.
Where's the state action?
The state action was, obviously that this individual had met with prosecutors, listened to her recording twice with prosecutors, been prepped by prosecutors, and they had the testimony, and she did it twice.
Is there proof that this was set up by the prosecutor?
I'm not going to make that allegation, and I did not there.
Sure.
In response to the state action, she had met with the state.
So was there, and help me with this because I'm not clear on it precisely, was there an objection that was made at the time?
Yes.
Okay. Was there a limiting instruction given by the trial court?
I do not believe that there was.
Was there one requested?
I do not believe that there was. But I will check that when I sit down. And if I could kind of jump out of order, another central part to this appeal was the use of the McLaughlin recording as it related with a prior consistent statement. We had flagged that issue pre-trial on the fact that it was not admissible, but the court allowed the 1992 interview in our opinion, improperly bolster McLaughlin's testimony. Again, you got a case with no investigation, no confirmation of the disclosure to the childhood friend Elaine, the parents, no pictures, no DNA, no search warrants, no going to the apartment to see if the child's statement could be corroborated, zero corroboration. And the only thing the state had was this recording. We attacked it pre-trial. The trial court found that under Tizard, it was a fresh complaint that would come in. We cited the trial court to State versus Livingston, which we're relying on today, where the Supreme Court held that the introduction of a recording in that case to a DCS employee was reversible error. So the consistent statement here was the case in its entirety, and they allowed Ms. McLaughlin to listen to the tape over and over. And what's interesting, why they were trying to shield this recording, the the court allowed them to enter the recording in through Tammy Mathis Judd, the DCS investigator. So you have, I mean, in the dynamic of the trial, we've objected stringently to the only piece of evidence, the audio recording of Ms. McLaughlin. My audio recording of Mr. Shaffighi has disappeared, and they get it in through the DCS investigator as a prior consistent statement on a different witness. So clearly it was a tactical decision to avoid her being cross-examined during, being crossed after her direct, but we're very adamant in our position that Tizard was not applicable, Heron was not applicable, and under State versus Livingston, the prior consistent statement should not have come in.
On the jury instruction, the Allen charge, can you help me understand a little bit about the argument that you're raising with respect to that? It seems, from my reading of the charge that was given by the trial court, that it wasn't a charge where the court was instructing jurors to give up their views that were consciously entertained in favor of someone else. It seemed to me that the trial court was more or less instructing along the lines of the pattern instruction anyway. How do you disagree? What's the best argument that would disagree with that observation?
If I may put that in context, trial was over Friday evening. They deliberated for a period of time. Friday evening, they came back and said that they were unable to reach a verdict. At that point, what our position is that the charge given by Judge Green mirrored the charge in Kersey, which was ruled impermissible. And the language, we juxtaposed the language in Kersey with the language in Shaffighi, where the court said, basically, the reason I'm suggesting doing this, it makes you look at it from a different perspective. I want you to work just a little bit more. Let's come back, see where we are, and address this again in an hour or so. Talked about, the trial lasting 3 days, and they come back exactly in an hour, and someone had changed their position. So it's our position that they should not have been, the judge should not have.
The issue in both Allen and Kersey, I believe, was the fact that the instruction itself encouraged people holding a minority view to reconsider their views in light of the majority. And that doesn't seem to have happened here at all. In fact, the trial court was simply asking people to listen to the views of their fellow jurors. Don't hesitate to re-examine your own views if you think they're wrong. How does that and how does the trial court's instruction mirror something like that was given in Kersey or given in Allen?
Well, we're relying on the admonition that the Supreme Court said there needs to be strict adherence to the language of Kersey. And we don't see that a lot. And in this situation, I don't think that charge was a strict adherence to the language in Kersey. And when it's made on a Friday evening, I just don't think it's appropriate. I think, the judge should render the charge in the context of a Dynamite Allen context or a deadlock jury that has been specifically approved by the Supreme Court in Kersey. I think deviation, modification lends us to having this dialogue today, Judge Greenholz. Sure.
The language, the suggested charge from Kersey actually was given by the trial court in the final jury instructions. Is that correct?
Correct.
Okay.
The other two issues, and I apologize, I've lost track of my time.
You're down to your reserve time. If you want to continue, you may, but it's up to you.
I do, if I may, because this issue is important. The issue on Darren Strange, the 702, 703 issue, where the judge would not let her opine on the ultimate issue, is set forth, I think, very clearly in the brief. Sentencing. I had the rare pleasure of agreeing with my colleague sitting beside me that there was error as it related to the sentencing. It was complicated because it involved the 1989 Sentencing Reform Act. The judge erred in applying factors 1, 7, 15, prior criminal conduct or misdeeds, not supported by the record at all. The next one, sexual gratification, not supported by the record in any way whatsoever. The authority figure that he relied on in 15, the record is silent on what weight he gave that enhancing factor. So you had the judge applying enhancing factors that were inappropriate as the law was right then. There was nothing in the record from the defendant, the jury verdict that could be inferred, et cetera. And then he gave the maximum in each range. There was a Class A felony, the rape, 15 to 25 at 30%, the B felony, 8 to 12. We addressed the very same issues. I will say that my colleague did a more artful job in addressing the sentencing law at that time. I discovered this weekend as I was getting ready. But we basically had the same sum and substance. The only thing that she did not address was the issue of he did not address the mitigating factor of sexual gratification. I know no injury as it related to the sexual act. The case law is a uphill battle, but the court was required under Biles to make a finding, which they did not. So
Mr. Isaacs, you're not only wanting us to send this back for resentencing, as I believe the state agrees we should do.
Yes, sir.
You want us to tell the judge which enhancing and which mitigating factors to use? Is that what I'm hearing you argue?
I would like a resentencing with some guidance to the trial court on what factors are impermissible based on the record under the laws that existed in 1993.
Okay.
So I'm not here trying the case and speaking to you at the same time again, Judge Easter.
Well, that wouldn't be.
I understand I've used my rebuttal time, so I will yield the floor.
If you have to come back and speak to me, that wouldn't be the end of the world, would it?
Absolutely not.
Okay.
Cheryl, would you mind if we picked up where your friend on the other side left off
Sure, with sentencing?
about sentencing?
Yes.
If we're if we sentence at the time of the offense, generally speaking, and at the time of the offense we had a system where enhancement factors increased the sentence, mitigating factors brought them back down. And if we believe that the trial court could not make findings that would increase the sentence, with the exception of a criminal record, either through Apprendi or Blakely, is the only, I'm wondering about what would happen on a resentencing. Would it be appropriate for this court simply to modify it to a 15-year sentence? Is there something for a sentencing court to do?
I believe that the case law that has kind of addressed this issue where the trial court just didn't apply the 1989 version. I think that this court has gone both ways, where it's conducted de novo review and imposed the sentence on its own, or it has remanded. I think this is, the state's asking for a new sentencing hearing in the trial court because I believe that enhancement factor 15 could be applied based on the defendant's occupying a position of private trust as the karate coach, given that that was not contested at trial. The reason we're asking it to go back down is for the trial court to consider how much weight it wants to give to that particular factor.
So it looks like both parties are asking the court to remand it for sentencing, resentencing. Is that correct?
I think it would be cleaner, but this court obviously can.
And there's all kind of potential mitigation that might apply that we don't know about, correct?
Right. I think the issue here is that this is not really a situation where the trial court complied with the 1989 version of the sentencing laws and started with the presumptive sentence. There's not just one issue, there's a whole, there are a variety of issues, and it might be easier to just have the trial court start over from the beginning rather than try to piece it all together. So I think we are asking coming at it from different directions, but ending up with the same result of remanding for resentencing
Okay, that's very helpful.
with Blakely. If there are no further questions about sentencing, just to take the defendant's arguments in turn. As to his claim regarding Ferguson, my recollection is that the record will speak for itself, but the trial court's focus on the polygraph seemed to be on the fact that it wouldn't be admissible. I mean, I think that the defendant has failed to show that a polygraph examination actually occurred, thus that there was one to be preserved. But even if we assume that it did, he's still not entitled to relief. He's failed to show that polygraph evidence was constitutionally material. I mean, Tennessee courts have repeatedly said that polygraph test results, testimony about them, this is not admissible. And there is other evidence to establish both his willingness to make a statement and his assertions of innocence. And that's really why he's saying polygraph exam is important and I'm entitled to relief because that didn't exist, and why he's saying I'm entitled to relief because audio recording didn't exist. What he's claiming that both of these pieces of evidence, he needs them to show that he gave a voluntary statement, that he returned from Iran, and to show that he gave the statement and he was asserting his innocence. But my recollection of the record is that the jury did hear that he had come back from Iran at least once, and the record will speak for itself as to that, but my recollection is that that did come out for the jury. And Ms. Judd testified that he came to the police station, that he gave a voluntary interview, and that he claimed that none of this happened. So all this information that he thinks that this missing evidence is important to establish came in through other evidence. And the polygraph evidence was of minimal significance given that it wasn't admissible and there was reliable substitute evidence, and the other evidence at trial was more than sufficient to sustain his convictions because the victim testified and her testimony was sufficient. As to the audio recording, I'd also note that there's nothing to suggest that the state intentionally destroyed the recording. Simply because the DCS interview continues to exist doesn't mean that the state intentionally destroyed the audio recording from the defendant's statement. We have in the affidavit from the state's investigator, my recollection, he said, this interview was recorded, I sent it off to be transcribed, I reviewed the transcript, and when there were parts that were unintelligible, I did my best to try to figure out what was said, but at the end of the day, the transcript reflected what the audio had captured, and that he had kept this in his files. The issue here is the span of time between the audio recording and then when we get to trial. Something happened to that recording in the 21 years where it was languishing in a storeroom. But again, the significance of the audio is minimal given the fact that the transcript existed, the fact that the defendant was able to elicit some of this assertions of innocence, voluntary statement through Ms. Judd. And the missing recording didn't prevent him from presenting a comprehensive defense to the charges alleged. He was the one who was involved in this recording. He would be able to assist in the defense by filling in any blanks to the extent that he remembered them. And as I've said, the other evidence that presented at trial was more than sufficient.
The trial court, with respect to the audio recording, did the trial court make a finding that that the audio was material?
I don't believe that it did. I'll say that this is not I don't recall the trial court's order being extremely detailed. I know that it's in the record and it seemed to focus mainly on the polygraph. I just can't recall the details, the extent to which it addressed it.
Sure, there was not a Ferguson instruction given to the jury, though?
Correct. What the court said was, I will give the Ferguson instruction to the jury if the state presents the transcript from the interview at trial, but the state never presented that transcript, and so the the court didn't give a Ferguson instruction, and I don't believe that the defendant requested one anyway, but that's also in the record. There is kind of a follow-up at the end of trial about what should we do with this Ferguson instruction, but none was given.
Okay, thank you.
As to Dr. Strange's opinion, the record shows that Dr. Strange was not able to offer a definitive opinion as to whether the victim had a false memory in this case. She went through all of the science. She opined that the victim's interview with DCS was highly suggestive, and that it could have led to the development and maintenance of a distorted memory. But when the defendant asked her at this pretrial hearing whether if she had an opinion as to whether the interview would have created a distorted memory, she said, "I can't say for sure, but I would be highly surprised if it didn't." And so this proposed testimony that a false memory could have existed would not have substantially assisted the trier of fact in understanding the evidence or determining a fact and issue, because the jury was more than capable of hearing her extensive testimony on the science of memory storage and how memories can become altered or distorted, and the proper method of interviewing children that was developed several years after the DC interview occurred, and the problems with the victim's interview and based on her experience and her expertise. But the jury was able to hear all of this and draw its own conclusions about whether a false memory could have existed. So the record supports the trial court's decision to limit this one particular part of her testimony. And even if the court did err in it, limiting the testimony, the error was harmless because it did not affect the trial outcome. If there are no questions on that issue, I'll move on to the defendant's claim regarding the victim's prior consistent statements. And the only reason that the victim's prior consistent statements were admissible in this case was because the defendant attacked her testimony on cross-examination as deliberate falsehood and as recent fabrication. So the defendant has called this a rather benign cross-examination, but the state's position is, if you read this record, this is not a benign cross-examination. It is very direct. It is very much an attack on the victim's testimony. The defendant suggested she was lying when she made the original report. He repeatedly confronted her about her claim that nobody else was present when the abuse occurred and that nobody saw the abuse, which we know is very common in sexual abuse cases. They're not usually performed with an audience. The defendant questioned her failure to disclose the entire story to her friend Elaine and her stepmother, said that she had dramatically changed her story within days, confronted her about altering her account of how often and when the abuse occurred, attacked her claim that she didn't realize that anything was wrong about her relationship with the defendant when she told Elaine about it. He said, "Now you get in front of the jury and you're crying and you're saying, 'I thought he was so terrible and coercing me. Which one? Which is it?' He said, 'You just had an epiphany when you talked to Elaine and went, wow, I need to talk to my parents. This may not be right.' Or I was scared and I felt I was being forced." I mean, you can't have it both ways. What's the truth? And to the extent that he attacked her in cross-examination as recently fabricating the story, he asked her, "Well, how many times have you listened to this?" When she said she listened to the recording twice, he said, "2, it took you 2 times. He contended she had no actual memory of events, that she couldn't tell the difference between what she remembered and what she had heard on the recording, and suggested she couldn't testify to the jury if she hadn't listened to this tape twice. So contending that she had no independent recollection. And this court, it can read the cross-examination, but it's the state's position that the nature of the cross-examination and the nature of the attack on the victim is what opened the door to her prior consistent statements. And because of this attempt to impeach her credibility, the court didn't abuse its discretion in allowing the statement. And although the state did ask initially to introduce it on redirect and having it be admitted through the DCS worker. If there are no questions about that issue, I'll touch on the defendant's argument regarding the refusal to declare a mistrial. As you mentioned, Judge Greenholz, this is a situation where there was no state action. This testimony that the defendant's complaining about was not elicited by the state. It was elicited by the defendant through open-ended questions on cross-examination that reasonably prompted the victim to make these statements. Second, the defendant never requested a curative instruction. And by failing to request that instruction, he failed to take reasonably available steps to mitigate any alleged error. And the state's proof was relatively strong given how the victim's testimony lined up with the elements of the offense and established that the defendant was the perpetrator.
Did the state make any argument along those lines or use that testimony in its closing argument?
I'd have to look back at it. I don't have a recollection of that, which is not to say that my memory is 100% accurate. But I don't believe that that was a basis for the state's argument, but the record will speak for itself on that.
So in other words, at least as to your recollection right now, after the statement was given by the victim, there it lay. No one ever made use of it again? Did any party make use of that testimony again?
I don't believe so. I don't have a recollection as I stand here today of that happening. As to the jury instruction to the deadlocked jury, that under Kersey is not a coercive instruction. The instruction to continue deliberations complied with the guidelines that are set out in Kersey. I told the jury that the jury came in and said they were deadlocked. The court said, I don't want to know what your split is. Don't tell me that. It just confirmed that the jury was deadlocked, told the jury to keep deliberating, and suggested looking at the evidence from all of the angles.
Didn't the judge kind of go out on his own when he said, look, if you're on one side, I want you to adopt the point of view of the other side and think about that and argue it, and the same for the other side. I don't recall I'd ever heard that suggestion ever being made before. What was that just kind of going out on the judge's own to come up with that, do you think?
I've not seen that particular language before either. I don't think that it rises to the level of telling the jurors to abandon their own beliefs or cede to the majority, which is what Kersey is concerned about. I think that even using the term adopt the position, that would be stronger than what the trial court said. I think the trial court just wanted the jurors to look at all of the evidence, make sure they were considering it from all angles, which I believe is consistent with how jurors are instructed. It is a bit different than your standard instruction, but I think the concern in Kersey is having a deadlocked jury told, you have X amount of time to come up with a decision, and directing it, particularly in a case where the judge knows that they're split, there's only two people in the minority, telling the jurors in the minority to reconsider the majority's opinion and see whether they can get there. That's not what happened here. The judge didn't know what the split was, didn't know how the jury was leaning, and just wanted to be sure that the jurors were looking at all of the evidence. So I don't think it rises to the level of Kersey.
I mean, trial judges are kind of boxed into a corner when it develops that there's a deadlock. How much can be said to try to encourage a verdict without overstepping? And I thought this was a different approach than what I have seen before. I'm not saying anything wrong with it, but trial judges certainly are boxed into a corner when this situation arises.
Correct. And I think that it's important here, too, to consider that the jury had only been out for 2 hours when they said they were deadlocked. And judges are allowed to instruct deadlock juries to continue deliberations if they think that it would be fruitful. So I think that just because maybe the language used is a little bit different from what we've seen before, it doesn't rise to the level of being coercive, certainly isn't encouraging a minority of whatever the minority position in the jury is to cede to the majority just to get a verdict and shut things down and head home.
Any concern to you, though, that the trial court instructed the jury that there has been a lot of time and expense that's been incurred in this? And that's one of the problems in Kersey. One of the problems with the Allen charge, right, is that implicitly what you're telling the minority, the people who hold the minority viewpoint, is said, look, if you can't come to a verdict, this has all been a waste of time, so you need to come to a verdict. Do you have any concern at all with the language that the trial court used here?
I don't have any concern with the language that this court used in this case. I think that there is a distinction to be made between this instruction and the instructions that we've seen in other cases where there was one where the court detailed exactly how many hours and how many hours he works in order to get to a case to trial. So I don't think that in this particular situation, what the trial court told the jury in terms of go back for an hour and let's see where we are, I don't think that rises to the level of an instruction that would be concerning under Kersey that would violate this coercive prohibition on coercive jury instructions. As to sufficiency, I'll just note that the state was not required to corroborate the victim's testimony with scientific proof or other witnesses. It is well established that a victim's testimony is alone is sufficient to support a conviction. And we've already discussed sentencing. So unless this court has any further questions, the state would ask that this court affirm the judgments of the trial court with the exception of sending it back down for a new sentencing hearing to comply with Blakely and the appropriate applicable sentencing laws. Thank you.
Thank you. Mr. Isaac, you pretty much have fulfilled your time, but if you have some issue you're just dying to mention on rebuttal and can do it in less than a minute, well, you're welcome to try.
I absolutely can, and thank you for your professional courtesy. The jury charge in the deadlock by Judge Green was erroneous for three bases. One, it talked about how hard they had worked. Second, it asked them to look at things from a different perspective, which singled out the minority jurors. And third, he talked about being back in an hour. So basically, they went back there going, we've got to make a decision because of these resources. We've got an hour to do it, and I need to revisit what I'm thinking. All he had to do, Judge Witt, as you said, was just say, go back and continue deliberating. You know, actually, when you read Kersey and whatever, you wonder why we're sitting here having to use a legal Rosetta Stone to interpret these judges and what they're saying when you shouldn't say anything. But this one was erroneous on those three factors. It was Friday night, it was raining, and if it caused those jurors to in a very emotional case where, I mean, it's the quintessential recipe for jurors to disagree. And I think Judge Green, in the way he couched it, based on those three reasons, it clearly violates Kersey. And strict adherence, are we going to say strict adherence means strict adherence? And I say the royal we, and I say that with the utmost respect. But if we're going to have a strict adherence standard, Judge Green did not pass constitutional muster. And thank you for the extra minute.
All right, thank you. Thank you both for your argument today, and that concludes this term, I believe. Is that correct? That's correct, Your Honor. We will be adjourned until